Welcome everyone to this Privacy Rules session of the Privacy Rules 3 days event. Yesterday we discussed about mergers and acquisition. Today we will be speaking about gaming. And I'm really pleased to have our panel of experts and guest speakers with us today. In particular, I'd like to thank Anna Grech from the Gaming Authority of Malta and Dan Chapman from the European Gaming and Betting Association for being with us as guest speaker in this panel. And of course, all our members from Privacy Rules that will help us covering this topic from different corners of the world. Victoria from Macau, and Markus from Europe, and Yugo from the US. And finally, of course, the chairman of the Privacy Rules Gaming Committee, that is John Eastwood, that will act as moderator. So a special thanks to you, John, for also helping me coordinating this wonderful panel. And yes, I think I leave it to you to introduce all the speakers and the topic. So thanks a lot, you all, and thanks also to our audience for being with us today. And the ball is in your court, John. So.
Oh, great. I'm John Eastwood. I'm a partner with the EGBA law firm in Taiwan, where we have fairly massive data centers, and our location has made it a key jurisdiction for data in both the senses of gaming in entertainment, the playing of gambling games as well as video games. We've got a great panel here today addressing aspects of both, and we don't have a ton of time, so I'll move quickly through the introductions so we can get right into what they've got to say. Our speakers today are going to include Dan Chapman, chair of the European Gaming Betting Association Group, Anna Grech from the legal counsel and policy analyst with the Malta Gaming Authority, Victoria White from the MDME firm in the key Macau jurisdiction, who's also going to give an overview of key developments in personal information law developments in Asia. Markus Myhrberg, the partner with Alexia law firm in Finland, will then examine online gaming from the EU side of things. Yugo Nagashima of the DC office of Frost, Brown, and Todd will be addressing some very important issues for data collection and privacy compliance in online video games in the US. We're going to start with Dan. Dan, the GDPR is very open for the interpretation in both its meaning and application, and rightly so, given that it's trying to cover all processing of personal data for any reason by any company. Now, to run smoothly and protect our customers, there's got to be a degree of unity and common application across our sector. So how do we achieve that without creating a barrier to entry or stifling competition? Dan's going to look into this and discuss some of the best ways to achieve this. One that's built right into the GDPR, so the industry-specific code of conduct. Dan, I turn the floor over to you.
Okay, well, thank you very much for that kind welcome. I do have to, just for the sake of humility, correct one thing, or at least clarify. I'm not the chair of EGBA. EGBA has a work group within it all about this code of conduct, which I'll discuss in a moment, and that's what I'm the chair of. I actually work for Hard Rock Digital as their data protection officer, so that's where I am at the minute. Anyway, to get onto the topic and not waste my own time, as you quite rightly said, a lot of people insult the GDPR and pick on it. And hands up, I've done my fair share. I've even done it to the politicians' faces, but the more you work with it, or at least the more I worked with it, I began to realize exactly what you said. All of my criticisms that it wasn't precise enough, it didn't actually answer any questions, it left so much open to gray areas. Rather than being the criticism I thought it was, actually, it's the absolute best thing they could have done. There's no way they could have been specific and catered for everybody. So I completely flip-flopped on my feelings towards how it was written. It's principles-based legislation, which means it has to be interpreted and applied in context. And it's that very reason which prevented any politician from getting it right for everybody. So if I look at our context, which is the online gaming sector specifically, it allowed us to come together, competitors, parts of the group alike, all around a table, being honest. EGBA facilitated this for us, and we're all extremely, extremely grateful. And it allowed a group of experts, both legal, technological, shall we say pragmatic, to get together and say, right, for our industry, what does this mean? When we say portability, what does it mean to us? When we say adequate security, what does it mean for gaming, which may well be different to, I don't know, an online video store. So this is the power of it, not the weakness, but you need somebody in the industry, you need somebody to create that. And when it is created, once it gets accepted by the EU, and that's where we are now, we're going through this particular churn with the EU, lots of recommendations, tweaks, etc. They're asking us to put in specifics, which is what people want and what they criticize the GDPR for not having. So you can see this is where they start to come in. And once accepted, it becomes the official interpretation of the GDPR for our sector. So it's not law, but it's not far off. That's what the courts, that's what the EU will refer to as the accepted application to our sector. And I'm talking about my sector, online gaming, but of course this principle is true for everybody. Any sector at all can get together and do this. And so from my sector, what I'd particularly like to say before I throw open to any questions, because I think to go into any more detail of how it works would have me taking up all afternoon. But in essence, it works. Get together, write one for your industry, get a big enough amount of peers to sign up to it and go, yes, I'm okay. Submit it to the EU, go through some drafting. Eventually, when accepted, it's solid. And we all get what we say was missing from the GDPR, which is sensible advice. So I'd like to suggest everybody hop onto the EGBA website. You don't have to be a member. Take a look at the code, download the code, read it, feedback. You can feedback to me or to EGBA. Because what we were very, very conscious of is that we didn't want to create a barrier to entry for anybody. This was not about somehow cornering the market through the back channels or stopping our competitors getting in on the game. And we want people to call us on that. We want people to hold that pledge up to us and say, no, this doesn't work. This will cost me 5 million and I just don't have that. So it's an open invitation, open season. I'd like anybody and everybody to do that. So it truly is representing the industry.
I think, Dan, that leads into a kind of a thing I could throw back here is I'm not a member of EGBA. You know, maybe I don't even want to be, but is it going to be all unfair that once this is approved, I'm going to have to apply it? Is this a recruiting drive for EGBA?
It's a fair point. It's a very fair point. No, it isn't. As I've already said, I represent EGBA purely at their request of somebody who's worked in the field for 20 years. So I have no vested interest in getting people to sign up. No, anybody will be able to feedback, member of EGBA or not, as already said. Anybody will be able to, very much like ISO 27001, if anybody knows that, the information security standard, anybody will be able to claim compliance with it. But I will say, if you want to fly the flag, if you want that image on your website, you will have to go through a certification process, which again will not be run by EGBA. So no, in no way are we trying to strong arm anybody or fill the coffers.
Could this be an extra set of handcuffs in an already hyper-regulated market? I mean, you know.
It could be. I mean, hyper-regulated is the right thing to say for the online gaming industry. I don't think anyone would argue there. I can see that some people could say, well, any more rules, anybody telling me a secure password is 8 characters long is just more that I don't need. But this was 6 or 7 operators around the table. We all had that fear too. Was no way we were going to make a rod for our own backs. So no, I don't think so. I genuinely think that what it is turning all of that GDPR that feels like trying to nail fog to the wall and making it something practical that you can look at and go, am I doing that or am I not? Because if I'm not, maybe I'm not interpreting it in line with the rest of this industry. So that's what we intended. We don't intend to say anything to people that is over and above what they would have to do anyway.
It's not about squeezing the little guys out, is it?
No, absolutely not. As I've already said, now I can only speak for myself here. I don't claim to represent a company, but that is absolutely against my personal ethos. No, competition is good. It's healthy. Everybody starts as a little guy. If you want to come at me at my company, if you want to take me on, if you want to beat me and steal my customers, then I'll meet you on that particular battlefield. I'm not going to try and do it through some clever political maneuvering in the background.
Well, great. Well, then, mindful of time, that's a wonderful presentation. I mean, are there any other, do we have any other questions from within the audience that, that we've gotten in, Alessandro?
Not yet, so we can move forward and then collect questions for the end of the session.
Excellent. Dan, thank you so much. I'd like to move to Anna Grech from the Malta Gaming Authority. So looking forward very much. Getting a chance to hear it from the regulator standpoint. I turn the floor over to you, Anna.
Great, thank you so much. So first of all, thanks for having me. Just by way of introduction, as you've already mentioned, John, I form part of the General Counsel Directorate at the Malta Gaming Authority, specifically within the departments of International Affairs, Policy and Outreach. And as part of my tasks, I also assist the DPO's department and team in tasks in issues relating to data protection, basically both that stem from the authority's own compliance with the GDPR and relevant data protection law, and also any issues that may arise from our licensees or stakeholders within the industry that is dealt with by our team. So just by way of clarification, as the name obviously says, the Malta Gaming Authority is tasked with the regulation and supervision of the gaming industry in Malta, both online and land-based. And so for this reason, we're not the supervisory authority in terms of GDPR. That is left within the remit of the IDPC, which is the Information and Data Protection Commissioner in Malta. But obviously, I mean, as the GDPR permeated every other industry, it did so in the gaming industry. And so we could see a need, both authorities could see a need through the queries that were coming in before the coming into force of the GDPR, that the industry does need some sort of guidance and the nudging towards a good application of this law. And so a lot of queries were based on, I mean, Dan kind of touched base on this before. It's, there was a lot of open space, a lot of space for interpretation, and the industry was worried about certain conflicts that were arising in the interpretations of the GDPR, and then also the existing frameworks that they already had to be compliant with. So basically, these guidelines were kind of an answer to that. And what I'd like to do is just go over a couple of main points. Again, if I were to do a detailed analysis of these guidelines, I think we'd be here all afternoon, but just some main points that are, important to mention, I guess. First one being the lawful ground of processing for operators. So obviously, one of the main things that the GDPR establishes is lawful grounds for processing. There are 6 grounds, and what the MGA and IDPC guidelines kind of fork out of that is 4, which gaming operators would generally use within their activities, and those are processing based on consent, processing that is necessary for the performance of a contract, and then processing that's based on legal obligation or legitimate interest. So the first three are fairly straightforward. The gray area and I guess space for interpretation comes when we identify legitimate interest. So once this interest has been identified, it is vital, excuse me, that the operators conduct a legitimate interest assessment. So what needs to be done here is understand whether this processing is necessary to achieve these objectives that have been identified. And then very importantly, conducting a balancing test. So basically ensuring that the rights and freedoms of the players and therefore the data subject are not outweighing the operator's interests. And what can be taken into account here is aspects such as the scale of data collection that will be conducted, the nature of the interests involved, the impact of the processing, and obviously understanding and considering any safeguards that can be put into place with regards to this processing. And so I think a very clear example of this would be the necessity of processing personal data when it comes to a player, for example, opting out of marketing communication. So it's really important that this is an important obligation on the part of the operator that marketing is not communicated to persons that have opted out of them. And here it's just absolutely necessary there's literally no other way to ensure this obligation but to process the personal data. And so what must be looked at here is that just ensuring that, for example, it's the minimum amount that is being kept to achieve this goal. Another aspect that the guidelines touch upon is matters relating to privacy policy. So the provision of a privacy policy is obviously kind of fulfilling the right of the data subject to be informed. And what the GDPR, I think, really emphasizes on is intelligibility in this aspect. And this is always very closely linked with use of clear and plain language, being straightforward with the information that you're giving. Obviously, the controller is probably the best person that's placed to understand what type of people will be reading this privacy policy. They know who they're targeting, they know who their customers are. And so it's up to them as the best placed person to understand this. And if I phrase my privacy policy in this way, it's going to be absolute gibberish. So it's not going to be fulfilling its purpose. So really just using clear language, putting the points out in a really straightforward manner is really important. And in addition to that, there's also a concept that the guidelines bring out, which is layering of information. So that's literally subcategorizing your information into separate headings, clickable headings, something that's user-friendly. So if I am a data subject and I want to understand more about a specific point, I don't have to read through a haze of text, which I don't understand. I can go to something very clear and understand the concept that I want to be understanding. And then obviously practical implications like making the privacy policy available upon registration, because that's obviously when you'll be getting the personal data, and always having it easily available and accessible to the data subject throughout the relationship. Just two more points. The guidelines speak about automated decision-making and profiling, which is something that's quite important in the gaming industry. The GDPR does not prohibit this. It allows it when it's expressly authorized by law, these exercises to happen. And so, for example, when it comes to for detection or specifically detection of suspicious betting patterns, it's actually really important for the operators to have this database of personal data to understand the behaviors of the players. What the guidelines say is that it's really advisable to have a human element, especially when you have decisions that are being taken that have some sort of legal effect or something similar to a legal effect, like terminating the services, for example. It's really important to just have a person there. You would have more of a processor kind of relationship if the affiliate would just be simply driving traffic towards the operator. So basically, in a scenario where the operator, unless it were for that partnership with so the affiliate, unless it were that they had that partnership with the operator, would not be processing this data, then it's obviously more of a controller-processor relationship. And of course, you can have a scenario where the two parties are determining the purpose and means of the processing together. So you have a joint controller relationship. So it's really quite interesting to see how specific dynamics, how little details of a relationship can really change the GDPR implications. And that's why it's really, really important to make detailed assessments of these sorts of arrangements on a case-by-case basis. So that's it for me, just a couple of topics that the authority believes that are important in the gaming industry, but we always urge you to read the whole document because it's all important, basically.
Well, great. You mentioned that the guidelines emanated from a situation where the authority was receiving a bunch of queries from the licensees about the application of GDPR to their operations, the way in which this could, conflict with their obligations under the gambling framework. So, can you give us a little bit of background on the clash?
Yes, definitely. This basically stemmed from concerns regarding the GDPR coming into force, and then the existing AML frameworks, and particularly responsible gaming framework within the whole gaming framework. So what's really important for operators within their activities is to build player profiles. And this is not just because of business interests, it's also really important for operators to be assessing risk based on these kind of models to monitor behavior, and to ultimately ensure that they are intervening not only when it's necessary, but also when they have a legal obligation to do so. So if there's some sort of problematic behavior that's coming up, they have a legal obligation to be intervening. So on the face of it, there was these kind of clashes where you say, oh, this definitely would conflict with a GDPR principle like data minimization, for example, because you're holding quite a lot of personal data on the individual players. But what's important to note is that ultimately the GDPR is not there to prohibit any sort of processing of personal data. It's there to provide lawful grounds to do so, so that you either have a legitimate interest or you have a legal obligation to be processing this information. I think what's an important point to understand is that the GDPR makes you question almost the necessity of the processing. So it's the general advice is never to do it on a ground of just in case I'm going to keep this personal data. There needs to be a legitimate reason or a legitimate interest. So I mean, for example, a really classic example I would say is the AML obligation, that if you have suspicious activity, you should be reporting this to the relevant authority, but at the same time you're not allowed to tip off the account holder, the player. And this, again, on the face of it, it jars with the principles of transparency. It jars with the right of the data subject to be informed. But really, if you have, for example, on the outset of the operator-player relationship, when you're providing that information through the privacy policy, if you're accounting for this possibility, so you are informing the data subject, listen, this can happen, then you're fine. You're not in breach, and you're complying with all the legal frameworks that you need to be complying with. So it's really about that's why the guidance was so important. That's why, I mean, there was all this hype about GDPR, there was all this worry. So it was very understandable that the industry needed some queries being answered, and also just some general guidelines as to how to act to be fully compliant. So that was the reasoning behind it.
Oh, that's excellent. That's excellent. I know that we have a question in from the audience, but what we'll do is we'll hit that in around at the end of the program, because we'll come back around with some more questions. Victoria, Macau is a massive gambling center, just like Malta is, and I'm curious. So you are going to give us a bit of an overview of what's happening in the region. And I'm very excited for this because I know a lot's going on, being in the kind of the Greater China region myself. So, hit us up with some of that.
Hey, well, that's great. Thank you very much, John. And just to say, it's a great honor to join this panel of experts and speak with you all today. I'm Victoria White, as John said. I'm Special Counsel and Head of Digital Transformation at MDME Lawyers in Macau. And I'm also a Certified Information Privacy Professional, Asia, by the IAPP. And my focus is really on digital and data protection matters. I should also say that previously I was Director of Regional Marketing at Marina Bay Sands, Singapore, and also Executive Director of Loyalty Marketing at Sands China. So I've got quite a good grasp of the practical issues for business teams when it comes to customer data and data privacy. So like John said, the focus of my section is really to give you all a snapshot of the significant data privacy developments in Asia this year, because I think these really may prove a tipping point and really a game changer in the way that companies and operators in the gaming industry approach data privacy compliance in the Asia market. We'll highlight some of the key practical issues that these new laws trigger, and then we'll look at a few strategies to overcome the challenges. Due to the time limitation, I just say that I may not have time to run through all the points that I'd really like to cover today, but I have included my contact details at the end, so please feel free to reach out to me if you'd like to continue the conversation and speak more about any of these points afterwards. So let's go to slide 2. And to set the scene, in August this year, the Chinese government passed its new personal information protection law, and that's already taken effect on the 1st of November. So this new law applies to companies that handle Chinese residents' personal information, even where the companies are located overseas, be it in the US, in Macau, or in Hong Kong. So the law has extraterritorial effect in a similar way to the GDPR. And it applies to companies which process Chinese residents' data, either to provide products or services within China, or to do data analysis on their behavior. So you may say, well, the law's not going to apply to our company because we don't provide any services within China. But if you have a website or social media channels that Chinese residents can use, or you're doing data analysis on Chinese customers' data, the law will most likely apply to you. And this is quite an important point as well, that even if it does not directly apply to you, you may have a Chinese media agency or a travel agency who give you access to customers' data, and they will be asking you to sign a data transfer agreement that states that you will comply with the Chinese law. So you can see that, at least in Asia, this extraterritorial reach of the Chinese law is really a first, and it certainly requires some close consideration. Similarly, in Japan, amendments were passed this year to its personal information law. Now, these amendments expand the scope of the existing law so that all overseas companies that handle Chinese citizens' personal data and provide products or services in Japan are affected. Now, these amendments will come into force on the 1st of April next year. So operators with Japan-focused teams or operations, you're going to have to determine if these new amendments kind of affect you, and if you'll need to overhaul processes before April. So taking a look at the main requirements of these new data privacy laws, can we just use the GDPR compliant processes as a default? Well, straight away, there's a new requirement under the Chinese law for overseas businesses to set up an agency or to appoint a designated representative within China to handle data protection matters and to record that with the Chinese authorities. There are also a number of other stringent requirements that we don't have time to go into today regarding cross-border transfers, the appointment of data privacy officers, collection of minors' data, data subject rights, and automated decision-making. So, ultimately, what are the penalties for infringing this new law? Well, the penalties are high, they are serious, and they include fines up to the equivalent of around $7.5 million US, or 5% of the company's annual turnover, in the instance of a serious offense. Switching to Japan, the new provisions also introduce increased data subject rights and also mandatory data breach reporting. Similarly, the penalties for non-compliance have been raised, with fines of up to the equivalent of around $800,000 US for corporations. We should also just say here that there have been amendments to the data privacy law in Hong Kong this year as well, although the provisions relate to doxing, so they're not so immediately relevant to the gaming sector. And also in Macau, we've seen an increase in enforcement by the data protection authorities against infringers. In 2020, the Macau Data Protection Office imposed fines, totaling the equivalent of nearly $1.5 million against companies for illegal use of personal data and also for failure to obtain users' consents. So let's go to slide 3. So now turning to the main issues for operators in the gaming sector. Well, clearly, due to the international profile of customers, it's likely that you may be processing personal data that is subject to an overseas privacy law. So what can you do? Well, we understand that some organizations have actually halted data collection and data processing from China until they have a robust data management solution in place. But often it's not really a simple matter of siloing data from customers of a certain country and then giving it special treatment. It's just not possible to do that with the existing operations. I'd say another problem is the vast array of data sources that are now used for collection of personal information. These are through in-market apps, WeChat official accounts and mini programs, websites, payment transactions, digital reservations, Wi-Fi logins. So ultimately, it's very difficult to have an accurate picture of which customer's data is collected from which source, before it's then pooled in a central database. Another issue is the introduction of data subjects rights. And, we think that this will likely lead to an increase in data access and deletion requests for privacy teams that they're going to have to handle. So let's go to slide 4. So ultimately, how should operators tackle this situation? Well, first of all, I'd like to say it's a really good opportunity to get your house in order and to carry out a comprehensive data mapping exercise within your organization. You may have a China team that you leave to take care of your China market. And probably now is a good time to check in to find out exactly what data collection and data processing and transfers they do to make sure that they have the processes that are going to comply. I'd say now is also a good time to consider adopting some of the new privacy tech management tools that are available. At the moment, you may be using very simple privacy tools, perhaps on your website. But I think going forwards, you may want to think about implementing a full-scale privacy management software solution. Having said that, the effectiveness of these privacy tech solutions is totally reliant on employees' understanding of privacy issues, not just in the privacy team, but throughout the business. The business and where the staff have contact with personal data in their everyday roles. So really, we see that employee training on these new privacy rules and protocols is absolutely vital. I'll just end up by saying that I think operators can really use their approach to personal data management to build a trusted reputation with customers within the gaming market, and certainly I think differentiate themselves from competitors in the Asia scene. So that will end my piece, and I'll hand back over to John.
Great. You mentioned data privacy training for staff. Is this going to be mandatory under any of those new laws? What's going to be the best approach for trying to do the training effectively?
Yeah, absolutely right. That's a very good question, because under the Chinese Personal Information Protection Law, Article 51 requires organizations to provide security education and training for employees. And it's absolutely critical to have this documented, in the case so that you can provide this evidence to regulators in future. I'd say the best way is to make the training very practical. I think we've all seen quite a lot of compliance training before that's very theoretical, very sort of classroom training, but it doesn't work in practice if the staff don't know how to apply it in their day-to-day operations. So I would say with your training, make it practical and make sure that everyone understands what's the important points are.
Now, can I eliminate the human beings? I mean, to what extent can data privacy compliance function be automated, or just do we have to suck it up and get extra headcount?
Yeah, well, I think these privacy, it's important to say, I think the privacy management solutions, they're really tools to support the data privacy teams and in no way to replace them. What they can do is to automate a lot of time-consuming tasks, particularly like data access requests or diligence for information. And what they can do is then help the privacy team to then do all of that in advance, and then the human element can then review it and approve it to sort of create efficiencies. But certainly we need the human element and the overall direction for these things.
Great. Well, now our next speaker today is going to be Markus Myhrberg. So looking forward very much to hearing the EU perspective. A little bit of a gear shift as well, because we'll be getting into online gaming now.
Just a minute. Yeah. Okay. Now, yeah. Thank you, John, and good afternoon also from my behalf. Yes, I'm Markus Myhrberg, coming from Lexia, a Chinese based in Helsinki, Finland. And today I'm talking about online games and especially from the GDPR point of view, including also what they call e-privacy. So, but I haven't divided those too much. But in addition to GDPR, which is the general regulation, we have the e-privacy directive in force, and which kind of gives some additional requirements to the GDPR regarding the privacy matters. So I'm just trying to share my screen from here. I think it is this one.
Oh, here we go.
Here we go. And then, can you see my notes now?
Yes, notes are still there.
Is it okay?
I think you should do swap.
Sorry, I can't hear you. The slides are fine. Sorry. Yep, I think so. Okay. Let's go. Few remarks how to be about the data collection and compliance of the online gaming in the EU. And I just picked up certain points here. I'm not going through too much the basis of GDPR or privacy directive. But from the practice, so some few remarks which have been pointed out or come across during the last 3.5 years we have had GDPR in force here. And making those few remarks here, starting from the personal data. When we talk about games, we talk about, of course, a full variety of different kind of personal data, which might include, and which is sometimes a little bit misunderstood, it includes only kind of registration information, what the player has given on themselves. But in addition to that, it should be remembered that there are a lot of other type of data which can be considered to be personal data, from all kind of following the players, how much they spend time there, what images they upload there, etc., etc. So just to remind, especially those who are in the beginning of the game career. So like it's always starts from to analyzing what is the personal data. The second point, what is taking up, what is The hardest part sometimes is the data flows, to really analyze what kind of, where the data comes, where it goes, who we shared it with, where we transfer it, etc., and where we stored it, etc. So it's crucial even in mobile games, etc. So a little bit more simpler games, it's crucial to analyze what happens behind the scenes, as they say, including, for example, your SDKs coming from partner firms or from the publisher, etc. So it is typically a point where data is shared. And if the data is shared out from the EU or EEA, the European Economic Area, which is a little bit wider, so then of course there has to be the special mechanism in place, where I think most important is what they call EU Commission's standard contractual clauses. This of course applies to those who are transferring information from the EU to third countries, not being adequate, as they say. There are certain countries where you can transfer without any additional mechanism. We could talk about the transfers to third countries for hours here, because it's a very hot topic at the moment in the EU, and there is a lot of difficulties and challenges regarding those to what they call supplementary measures, how to analyze the country you are transferring the data is safe enough. And you should remember here, which is sometimes misunderstood, so that transferring includes also the possibility to access from a third country. So if there is a second line support out of the EU regarding your game, that's also transferring data to third country. Then pointed out just shortly information. There are articles 13 and 14 in the GDPR saying exactly what you should inform and actually follow those, but maybe the biggest problem is how to provide the actual information in the beginning of the game, and so it will be available for the gamers or players. And this is, of course, partly a technical or design. Sometimes game developers say that it rules or it's not good for the design, but actually you have to take care of this too. And then what is like still one of the hardest part of the game, GDPR game, is the legal basis for processing. So you can't process any personal data without knowing that what is the legal basis for processing. And there are kind of 6 different options where, of course, regarding the games, we take normally the contract or terms of use, which is mostly the most obvious and applies to most of the information or personal data. But then sometimes you have to have certain consents and maybe for certain purposes, such as marketing, using what they call legitimate interest. And this is just like to pinpoint that you should also know the basis for any processing. And do not forget that one of the main principles of GDPR is the data minimization. So as great it would be to collect as much information as possible, so consider, is it necessary really? Then in the game industry, of course, it's very typical that we face the problems regarding processing children's data. And there is kind of 2 aspects. One aspect is that which reflects back to the information is that actually how to inform the young players clear enough what happens in the game. And there we have had few cases, but of course TikTok is not directly from the game sector, but there is a very good example especially from the UK regarding the TikTok information obligations, or what was like required from that service, which is typically used by very young users. And then the problem of the variety of ages in the EU, and this is of course a bit different for example, from the US, where we will hear more about the COPPA regulation, where you have only one age limit, which is 13. In Europe, you have multiple, and different countries have different age limits. And that's where you have to decide, do you take the highest, so the 16, or what is your approach here? Normally, of course, you can't have it by country. And then some other certain points to be considered how to be compliant, which is, I would always pinpoint the marketing and profiling, and if there is consent needed for these two. And then what they have a specific clause is the automated decision making, which is in most cases forgotten that actually that's the case where you should inform about this kind of processing of data, including also what kind of methods you're actually using there. So this was very quick overview of the crucial points, how to be compliant with your games in the EU under the GDPR and partly e-privacy.
Well, great. That leads us right into our next presentation. I know we're going to have some questions. We've been getting some that have been popping up, but hitting up a very similar set of ideas, but from the US context. I'd like to welcome in Yugo Nagashima from Frost Brown Todd.
Hi, it's a pleasure to be here, and I am a member of the Washington, D.C. office of Frost Brown Todd, and I am also information privacy professional, just like Victoria, but I have one in the US and Europe. And let me just dive right in. Alessandro, could you put up the slides? So today, what I want to talk to you is about, so the US has a federal system, which is there's federal law, which covers the entire United States, and there's state law. So one on the federal side, which is COPPA, Children's Online Privacy Protection Act, and the other one is the CCPA. And let me start with COPPA, because I think this is a law that people are not really paying attention to because it's relatively old. It's from the .com time, 1998, and it basically covers how parents of a child, and a child is defined as someone who's under the age of 13, should have direct notice, and after that, the operator will have to get a verifiable so they have to get direct notice, and it's got to be before the information is collected and it's used or disclosed. And then the operator also needs to receive verifiable consent from the parent. Next slide, please. So this is a quick overview of the operator's compliance requirement. So you have to provide a notice. You have to also provide it directly and then obtain verifiable parental consent. You also have to provide reasonable means for a parent to review the child's personal information collected, and it cannot be a condition for a child's participation of the service. And then at the same time, you have to maintain confidentiality, security, and integrity of the personal information collected. Next slide, please. So one of the big issues for COPPA is, what is verifiable consent? Can it just be that online, let's say you have an app and you basically ask for the age and the response was they're under the age of 13. Can you just say, hey, does your parents consent? Yes, no, please check one. Yes, done. No, that's not the case. There's very specific examples that you can follow. And some of the examples are listed here, which can be providing a consent form and having it signed by the parent, mailed, faxed, emailed, or other uploading mechanism back to the company. Another way to do it is require a parent to use a credit card, because typically in order to have a credit card or debit card, you would have to be over the age of 13. And it would show that it's a grown adult that's consenting to the activity. Another way is to have a parent call a toll-free phone line or a video conference and speak to someone who's trained so that they can confirm and verify the consent from the parent. Another way to do it is verifying the parent's identity by having them email a copy of a government identification. And we've seen this with a lot of apps, especially with the financial apps. And then that verifiable identification will be checked against a database. And once it's confirmed, the parent's identification is deleted. There's also something called Email Plus, which is you can use an email coupled with other additional mechanisms that the technology offers to basically confirm the identity of the parent and have that consent. So that's a mechanism of verifiable parental consent. Next slide, please. And being mindful of time, I'm not going to run through all the exceptions, but there are exceptions to collecting the child's information. And basically, if the simple thing is, if your app is geared towards someone who's over the age of 13, I think you're in good shape. You may not have to worry about COPPA, although you should think about it. But if you're not, make sure that you either comply and get the verifiable consent, or you meet the listed exceptions. And again, there might be additional exceptions, but here are a couple of good examples that you will have to consider to see whether you have to comply with COPPA or not. And why is this important? And that is because regulators are actually enforcing COPPA. Next slide. So one slide back before this. Thank you. So just this August, the state of New Mexico, the Attorney General of state of New Mexico has filed a complaint against Rovio Entertainment, which is the Angry Birds company, and for the violation of the COPPA laws. And the claim is this: the complaint alleged that Rovio has a development kit, a software development kit, which is designed to collect information from children. And when a child plays the Angry Birds game, there is no direct notice to the parent, which then would require the parent to basically give verifiable consent. And what the AG is arguing is Angry Birds is clearly a child's game. And the reason for that is it's a everyone rated app, and it's very cartoonish and geared towards appealing to children. They're also marketing the content, which is the Angry Birds character and the pigs, which are plush toys, children's puzzles, coloring books, and lunch boxes. And also the marketing in the areas of entertainment, it's all geared for children. And because of that, it would be difficult for Rovio to argue that its game is not geared towards children. So these are some of the aspects as you develop your apps or video games that, are we selling this towards children under the age of 13? And how are we marketing this? This is something to consider. This might be more applicable to, for example, Digimon. You may have to think about it. But if you're doing Call of Duty, maybe you don't have to consider this so much. So these are the type of items that developers should be thinking about. So next slide, being mindful of time, next slide. I'm going to quickly run through the CCPA, which is a state law. It's the California law. And again, if you're not in the state of California, why should you care? Because like the GDPR and also the Chinese personal protection law, and I guess the Japanese law as well, the California law may apply to you. So if you have a website or online service that has California customers, and if you have a gross revenue of $25 million, or if you have personal information of 50,000 or more California residents, or you drive 50% or more of your annual revenue from selling consumer information, the CCPA may apply. I think for the gaming industry, it's probably the second. Having more than 50,000 residents' personal information might be the standard, but also watch out for the gross revenue, because this is not just California revenue or revenue from the California residents, it's the entire revenue. And just to talk about the CCPA rights are very similar to the GDPR. Some of the major ones are right to access personal information, right to know what personal data is being collected before collection, and right to delete and correct personal information. And here's are some of the differences and things you should watch out compared to the GDPR. So next slide, please. So one of the things you should watch out is that we see that when you give your personal when you think that CCPA applies, you have to give categories of personal information that is being collected. And a lot of times in the video game industry, this is not being done according to how the CCPA is required. So this is something a game developer should be watching out. The next issue is, once the user or consumer gives you a request for their data privacy rights, you should confirm receipt within 10 days, because that's a requirement under the CCPA. And finally, this is a very important one. The CCPA specifically requires having a "do not sell my personal information" link or on a website or on an app, which then allows the consumer to opt out of sale or sharing of the personal information. This could be done in a web page, and at times it also requires a toll-free number. So make sure to comply with this aspect of it, in addition to complying with other laws like COPPA or the GDPR or the PIPL in China. That's it for me, John. Back to you.
Well, that's excellent. That's excellent. Thank you so much. We have some questions in here. I'd like to throw out to let's see, to Markus and also to Yugo. Okay, George Binnis asks that you both mentioned the privacy of children. They're some of the most passionate gamers. Is there a regulatory trend, industry coordinated policymaking, or others to really enhance their protection? Throw it back to you guys.
So, Markus, do you want to start, or do you want me to start?
You go, please.
Okay, so I think what we're seeing industry-wide is, not industry, but like the data privacy worldwide, is there is an increased care for children's privacy rights. We're seeing more regulations, more laws being implemented. And as you've seen in the New Mexico versus Rodeo case, regulators are starting to enforce an old law from 1998. So I do think there's a move towards enhancing children's data protection. And this is something, especially because video games target children, may not be under the age of 13, but do target children. The game developers should be aware that they should comply, and they should be on top of following up with the children's data privacy rights.
Yeah, I do agree. Actually, there hasn't been too many cases in the EU, which is a surprise, but still starting to come, and starting, as already said, from the information rights. But actually, what comparing to COPPA, we have still the problem that we have no actual praxis regarding how to get the consent, for example, in the EU. So that's a little bit weird, and that's where I would like to see a little bit clearance from the authorities to how should it be solved in practice.
Great. Thank you so much. And then we have I think a question that maybe a good one for Victoria, which is which organization can ensure effective training and related auditable verification? Because I know that we touched on training a bit in your presentation as well as something that could be very important across multiple jurisdictions.
Yeah, absolutely, John. I would say the main providers are sort of law firms and privacy associations. The main benefit of, say, working with a law firm is that the training can be tailored to gaming and the operator's business processes and operations. You get privacy and gaming law experts together to provide the training. So it's more likely to be effective, because it's one thing to do the training just to tick a box, but it's another thing to do the training to actually prevent privacy infringements in future, which is the real business case. Other training by privacy associations is very good, but maybe a little bit more general and possibly less relevant to the day-to-day operations of the business.
Well, excellent. And we have one, I think, aimed at from Anna Ferreira for Anna. Malta has been traditionally the center for gaming in Europe. Is the progressive implementation of the GDPR impacting the industry, possibly forcing it to migrate? What's your thinking on that?
I mean, we certainly understand the implications of, you know, these really comprehensive laws that really put a lot of compliance liability on the operators. However, I mean, I wouldn't go as far as saying as they're pushing them out. We really, I mean, I can only speak on behalf of the MGA. However, I do believe that the IDPC is aligned in this. We're really open to communication with the operators, and you know, we want to see operators and the industry succeed, because ultimately that would mean that players and the subjects are protected. So you know, we don't want to see failure. We don't want to make it too difficult to not even be able to comply, or to make it too burdensome to comply. So although we understand that there are you know, it is burdensome, it is a huge compliance activity, we still believe that, you know, through guidelines, through, I mean, even EGBA's code of conduct, it's there to assist, it's there to guide, and it's there to ultimately make it easier. So we do our best to, you know, to soften the process as much as possible.
Now, we have another one in that comes in for the Greater China context. Let's see, from one of the attendees: given that China is a totalitarian surveillance state, who is monitoring and regulating compliance with the PIPL? Oh my goodness, I just asking that question, I could end up in jail. But Victoria, what do you take on that? Like, you know, who's watching the guardians?
Well, yeah, I mean, certainly there's in China now they've got they're setting up the regulator for the new PIPL. Yeah. And you know, question of that, obviously that is, again, it's a government regulatory body. And also because the law is obviously very new, we have yet to really see how enforcement will play out. But I mean, certainly sort of in the last couple of months in China, we've seen, you know, particularly in the tech industry, a lot of investigations into very large tech companies who have then sort of been issued with orders. This is basically under another Chinese law, you know, to update their processes. And you know, there was the case that in July that Didi it received a verification notice, rectification notice, and you know, until they did that, its app was offline in China, which is obviously, it's a serious issue. So I think it's a good question, and just to underline as well that sort of, you know, privacy compliance is really business critical going forward. It's not a nice to have, it's essential for the operations of the business. So it's yeah, that's certainly something. And I don't know if you can add anything further to that, John.
Well, I think you know, sometimes people miss that there's a very human element to the problems that the Chinese people are people. You know, for years there's been abuses that have gone on. So if you have while you're still at the hospital, having just given birth, you're already getting phone calls from, you know, various suppliers who want to, you know, hook you up with diaper delivery services and meals and things like that for the, you know, postpartum period. And you know, the ink is, you know, barely, it's still wet on the contract when you buy a condo, and you're already getting pitches from construction companies who'd like to come and want to demonstrate what kind of kitchen they can build, because there have been so many abuses for so long. You don't have, for decades, there was very little protection. People could just buy information. And I think there is this very human element where, you know, people can be very cynical, but there is a really important just kind of invasion that happens all the time where, you know, enough is enough. Even if you're, you know, lowest, factory worker on up through the big guys in the political halls of power, there's issues. But we also have another question, which is, comes in, and I think this is a good one just to kind of throw out to the group, which is, anti-money laundering efforts require acquisition and monitoring of data. Since privacy regulations are getting more and more complex, can they represent a shield for money laundering? Could it be a other illicit activities? Is it that kind of goes beyond our thing, but beyond gaming? But I just thought I'd throw that out there. It's like, certainly, the issue of money laundering and people moving money across borders. Certainly in the China context, it was always famous with some mayor of a town or some provincial official would sneak across with his annual budget and try to throw it on number 33 over in Macau. So I'm curious, just to throw this out there, what where you take, because I think there is a legitimate need for an examination of anti-money laundering things, but where do you see it from a standpoint where we're at in the gaming area?
I'm happy to jump in and give a quick answer. Actually, it's extremely relevant for our area. There is so much and so many links to organized crime, money laundering, which is done through gambling, both physical and online. So it is a really good question, and one that I've been dealing with personally very recently and very in depth with certain European countries' supervisory authorities. I actually don't think that it can provide a shield for these things, the increased focus. People may try and use it as such, of course. They're bad guys, they want to get away with things. But if you look at the GDPR, you've got reasons which can counter so much of these things. For example, legal obligation. You've even got public good if you want to go that way with it. Personally, I'd prefer legal obligation, but there's a range of justifications within the GDPR which can block deletion requests. It can block even access requests, to the degree that you don't even have to admit you have data, let alone what you're doing with it. So my honest opinion, and the opinion I was espousing to all of these supervisory authorities quite robustly, is that no, the GDPR should be and is allowed to counter these other concerns.
Great. And we have a question coming in from Eduardo. Speaking about gambling, is the data of gambling addicted persons treated in a different manner? Should they be? And I think that also ties back with a bit of an issue that I think we thought about from the standpoint of the regulator. Anna, what do you think on that one?
Yeah, interestingly, the Multi-Gaming Authority within their guidelines have specifically said that so there's a differentiation between self-exclusion data and problem gambling data. I mean, it's a blanket statement. As soon as there is medical data involved, as soon as there's a doctor's report, any mention of health, be it physical or mental, it's obviously considered health data. It's obviously a special category of personal data. However, the authority has taken the stance that self-exclusion data on its own as a generalized category would not be automatically considered so. And that's purely because, I mean, as a general category, of course, we're speaking here. Self-exclusion is part of an RG toolbox, basically, a responsible gaming toolbox that operators are obliged to offer to their players. And so it might just be a case where a person is cautious of problematic behavior that may occur due to excessive gambling, or is just a cautious person, just does not want to gamble in certain parts of the year, or is basically controlling their gameplay preemptively. And so if it's simply that case, it should not, it does not need to be considered special category. But again, that's also the importance of having trained personnel interacting with your players. It's really vital that as soon as any sort of health data comes into play, any sort of information relating to a person's health, then that is categorized differently. Then it's certainly a special category of personal data and certainly needs to be subject to the additional safeguards that the GDPR speaks about.
Dan, I know you follow this issue very closely too, don't you?
Yes, absolutely. It's I can only agree with Anna. It is special category data, no doubt about that. It has to be treated differently. There are different rules, different levels of control, different retention policies. The second health is concerned. Yes, absolutely on board. But again, just like Anna says, and just as I said when I was mentioning applied in context, if the context is somehow aggregated data or self-exclusion data which doesn't list the reason, then it may well be excluded from that definition.
Great. And then let's see, we also have a question that comes in. Let's see. Denmark's data protection legislation deems GDPR as applicable to deceased individuals for 10 years after death. GDPR applies to natural persons. This flies in the face of that. Are we starting to see cracks in the uniformity of GDPR being applied across the EU equally? And I know we don't have any Danish lawyers on our panel right now, but I was wondering if throw this open to see if anybody's been monitoring this or looking into to the issues of different applications across EU jurisdictions. Markus, or
actually, yeah, I haven't followed if we talk about deceased people here, so it's. I'm assuming it does not apply as such, but if the Danish authorities have taken that point, so unfortunately I wasn't aware of this. These very specific questions not actually come across too much. So what is the actual praxis? Of course, it should be similar everywhere in the EU under GDPR, but here we can notice that actually at the end of the day, it's not. Sorry, I can't give any further advice on this matter. Maybe we can come back with this.
Yeah,
sure,
if I can jump in, sorry, John, but we are a bit, we need to be a bit cognizant of time. We are already 10 minutes late, but there were lots of very interesting questions that we were receiving. So I left it going a bit forward because I think it was really interesting. But is there any conclusion from your side? And then also from our speaker? And thanks a lot, because that was really interesting and lots of questions from the audience. So very good to hear and interesting to listen to.
Well, it's a great pleasure to have this panel of experts. One of the things that it does draw us together is an awful lot of issues that are, there's an awful lot of overlap. And the fact that my own work kind of crosses over into both aspects of gaming makes this an absolute pleasure to have all of you guys on board. So I want to first off give a big shout out and a thank you to all of our members of our panel. And also just the to notice the commonality. There's so much that's accessed online. There's so much, and in truth, we're dealing with entertainment areas, things that are tremendous fun, and which involve certain amounts of accountability and information that goes in there. Whether it be in order to collect your winnings or to be able to shout down a 12-year-old or a 13-year-old on the other end of the planet as they're shooting you. It's going to be a lot of, these are great issues, and it gives us a lot of room to hold more of these panels, I think.
And if I may, John, I think there was just one, as you moderated so well, you were so generous with all your colleagues, but I saw that there is a question I was just reading that maybe is for you, that was on Taiwan data centers. So maybe you can conclude also just giving a tip on that.
Well, this is a bit of a fascinating, thing for us. Taiwan has large data centers, so that's the question. It comes in about Taiwan has these large data centers, and what's the impact of all the of all what the speakers presented here? And I think what we see here in Taiwan's a funny jurisdiction because gambling, gaming here, betting is so limited and so illegal and so in one sense, and yet a lot of companies use the data centers here for their operations elsewhere, and they have an awful lot of customer service people here, because it turns out to be that people in Taiwan speak Chinese and speak Japanese, and Taiwan was a Japanese colony for 50 years. And so linguistically, it turns out to be a place where people put a lot of customer service centers to deal with making sure that their gaming customers are able to click on the right things in order to place their bets and so on. The servers itself, between Google and Microsoft and many other companies putting multiple ones here, the sheer number of undersea cables coming into Taiwan, that from a national security standpoint, the US has been routing a lot of people to Taiwan instead of to other countries in the region. And we can even see that in terms of the flows of information. So Taiwan has basically attracted a massive pool of information, and therefore also has a massive pool of companies in both of these industries, both aspects of the gaming industry, that are here, that come here and want to have advice on what they need to do, since a lot of that stuff is stored here. So that's how it affects us mostly. Okay, perfect, John. That's extremely interesting. So thank you also for bringing your part in this panel with a view on Taiwan. Any concluding remarks? Because we are really late, so I would like to speed it up, but it was extremely interesting. So thank you. Oh, it's a great pleasure. Thanks everyone for coming out tonight. I'm really glad that we were able to get through so many questions, and we obviously have ones we didn't answer, but we'll be able to put these through the next session, because I'm sure we'll have more of these. Yeah, absolutely. If I can complement on these, we will be happy to receive also other questions to our email, that is info@privacyrules.com. We'll collect all the questions of this panel. I saw some questions that were related to a recording of this session that is recorded, so we will publish it so that everyone can watch it again or watch it for the first time. And there were lots of topics we discussed about from the new regulation that are coming. I think we were lucky because we had a lot of different perspective, but we know that the entire world is moving in the privacy sector, and there are new laws popping up all over. The PIPL was rightly mentioned from Victoria, was discussed among our team also last week in another event, because it's a really very relevant one, but there are many others moving. So we have to keep an eye on everything that is happening all over. So thank you all very much for being here and dedicated time to this in order to bring this perspective and let our audience understand and feel how important is this. That's all from our side. I would like again to thank our guest speaker Hannah and Dan for being with us today and providing us with their very relevant perspective. Thank all our speakers, our members, and you, John, in particular, to act as moderator and really bring in this interesting discussion in the best possible way, and our audience, of course, here today and also in the recorded version, for being with us. So thank you all. Thank you, Alessandro.